Assalamualaikum and hi everyone. My group and I want to present the case review that has been chosen before, which is the case of Jordan HUAN against SUAN CHUAN and others. So, this is my group members. My group consists of 6 members, which are PRIYADHARSHNI, HANIFF IMANN, me, PUTERI ALIYA, BATRISYIA, BRENNA JING, and TRISHA SELVANTHIAH. Next, the content for the case review consists of facts of the case, issue, judgment, ratio, decidendi, commentary, and also conclusion. So, to know more detail, I will pass to the next presenter. Welcome.
Hi everyone, my name is BATRISYIA binti Mohamed ROMIZAN 078408. Today, our group will be presenting a legal case study, which is Jordan HUAN v. SUAN CHUAN and others, where it is held at the High Court of Kuala Lumpur, dating back from 6 December of 2012, which was cited in Series 4 of the 2013 Malayan Law Journal, with several defendants associated with a local motor racing event. First, as you can see in the pie chart above me, is the director and shareholder of ALIYA Motorsports Sdn Bhd. Additionally, the director and shareholder of Team Empire Motorsports Sdn Bhd as well. Furthermore is ALIYA Motorsports Sdn Bhd, the company itself. Another is a private company owning Sepang International Circuit. And lastly, a registered sports organization controlling the automobile competitions in Malaysia under the Sports Development Act of 1997, which leaves us with 5 defendants in total for this case. On to the next slide is the background details, which are as follow, whereby Jordan HUAN, the plaintiff, was a student at Automotive College, where he trained as a mechanic and pit crew member during the local motor racing event in 2009 until 2010. Key legal facts to be taken note in this case is duty of care, whereby the defendants were legally obligated to ensure the safety of all participants at the motor racing event, which involves adhering to the principle of duty of care to prevent foreseeable harm. The High Court found that the defendants breached this duty by failing to enforce reasonable safety measures, such like acquiring a protective fire suit for crew members, which led to injuries sustained as a result of fuel spillage and fire during the refueling process. Subsequently, the court also applied the Caparo test to establish whether the defendants owed a duty of care to the plaintiff, which considers 3 factors. Firstly is the risk of fire, which was foreseeable by all parties involved. It was clear that the possibility of a fire in the pit area was high, given the nature of the activities taking place there. Secondly, there was a close and direct relationship between the plaintiff and the defendants. Jordan's role as a crew member placed him in direct proximity to the hazardous refueling process. Lastly, it was deemed fair, just, and reasonable to impose a duty of care on the defendants, especially on the third defendant who played an active role in the event's organization. That is all for facts of the case. Now on to the next presenter, which is PRIYADHARSHNI.
Alright, thank you so much, Betty. My name is PRIYADHARSHNI and I will be explaining about the issue of the case, which is the most easiest and simplest part of the case, wherein the issue in this case involves whether the defendants, including the motor sports company directors and the owners of Sepang International Circuit, as well as the National Motorsport Body, acted negligently in ensuring the safety of the participant and also the crew members during the MADIHAH Millennial Endurance Race, or we are known as MMER.
Now we move on to the argument of the case. The first argument is plaintiff claims against the first defendant and second defendant. The plaintiff claimed that Team ALIYA Empire Motorsports Team AEM, officially registered to compete in MMER 2010, was a collaborative effort between the second defendant's company and the third defendant. The team, which included the first defendant, the second defendant, and Dennis Lian as drivers, operated under the Team AEM brand without explicitly reflecting the entities involved in the collaboration. The division of responsibilities within the team was clear. The third defendant was tasked with securing sponsorship and financial contribution, exemplified by 2,000 ringgit Malaysia sponsorship from Malaysia Kuala Lumpur, while the third defendant provided crucial operational support such as crew members, safety briefings, and equipment testing. Evidence presented includes invoices addressed to Team Empire Motorsports Sdn Bhd for safety gear and car parts, as well as testimony confirming that the second defendant's company provided and registered a racing car a Lotus 2/11 under the second defendant's name due to regulatory requirements. The group, comprising members recruited from the automotive college and the other personnel, was managed and paid by the second defendant's company as demonstrated by the salary checks and bank statements. The detailed financial records further show payments for the team expenses, including workshop rental, internship allowances, and equipment purchases, substantiating the claim of extensive operational and financial involvement by the second defendant's company in Team AEM's MMER 2010 participation. The plaintiff's claims that emphasizes the substantial involvement of the first and second defendants in the operational and financial management of Team AEM, presenting detailed evidence, support their contribution and responsibilities. The claim underscores the structured division of roles and the significant efforts by the second defendant's company in ensuring the team readiness and participation in the MMR 2010 race. Let's discuss about the liability of the first defendant and the second defendant to the plaintiff. The plaintiff, a crew member of Team ALIAS Empire Motorsports Team AEM, was an invitee when a fire broke out. The key issue is whether the first defendant and second defendants owed him a duty of care. The plaintiff alleges negligence against the first, second, and third defendants. The first defendant, a driver and director and shareholder of the third defendant, did not assume a personal duty of care. Legal principles protect company officers from personal liability for corporate actions unless they explicitly or implicitly assume such a duty, which the first defendant did not. The second defendant's company and the third defendants had significant role in Team AEM operations. The second defendant company provided crew members equipment and safety briefings, while the third defendant secured sponsorship and financial contribution. The plaintiff was present due to this company's involvement. The court concludes that duty of care was owed by the second defendant's company, and third defendant did not the first defendant individually. Therefore, the claim against the first and second defendant is dismissed with cause. The next argument is the plaintiff claims against the third defendant. The plaintiff claims against the third defendant centers on their duty of care arising from their collaboration with the second defendant's company in the MMER 2010 race. The plaintiff, a crew member, was injured during a pit stop fire, a possible risk given the conditions. The third defendant, who primarily responsible for the sponsorship, as we mentioned before, they failed to limit the crew members in the pit area during the refueling, contributing to a hazardous condition, and did not ensure the plaintiff had a fire-resistant suit. Applying the Caparo test, the injury was possible. There was a close relationship, and it is fair to impose a duty of care. The third defendant's involvement in operations establishes this duty, making them liable for the negligence and breach of duty leading to the plaintiff injury. On to the next argument, which is the plaintiff claims against the fourth defendant. The court found the fourth defendant breached his duty of care to the plaintiff. Video evidence showed that the absence of fire marshals and the failure to ensure the plaintiff was wearing a fire-resistant suit during oil refueling, leading to his injuries. Citing precedents, the court established that the fourth defendant, as the pit area occupier, was responsible for the safety. The injuries were possible, and reasonable safety measures would not have imposed an undue financial burden. Given the high-risk nature of motorsport, stringent safety protocols were necessary. Applying the Caparo test again, the court concluded it was just fair and reasonable to impose a duty of care on the fourth defendant who breached this duty, making the plaintiff injuries actionable. Lastly, let's move on to the plaintiff claim against the fifth defendant. The court found that the fifth defendant owed a duty of care to ensure the MMER race was safe before issuing a license. Evidence showed that the fifth defendant's cretineers and an FIA official inspected the track, meeting their safety obligations. Citing the Waterworth versus Goodwood Road Racing Company Ltd, the court concluded that the fifth defendant had fulfilled his duty by taking reasonable safety measures similar to the Motorsports Association in Waterworth case. The fifth defendant's responsibilities included track inspection, licensing, and ensuring marshals, ambulances, and safety equipment were present. The court determined that the fifth defendant acted reasonably within his scope, ensuring the track's safety. Consequently, the plaintiff claim against the fifth defendant was dismissed as no breach of duty occurred.
Okay, thank you. Now I am presenting about the judgments rendered to the first and second defendants. In this case, the court dismissed the judgments for the first and second defendants about the actions against them. Both were not liable for the negligence and the loss suffered by the plaintiff. The racial dissidenti here was that the court found no duty of care owed to the plaintiff by the first and second defendants. In my personal commentary about this case, about the judgments, I agree with the court judgments that the first and second defendants owe no duty of care to the plaintiff. They do not need to be liable for the incident suffered by the plaintiff. In order to convict the defendants, they must have a duty of care as stated in the trivial Avery and Addison's case, and the neighborhood principle that derived from the leading case Donahue and Stevenson's. To establish the duty of care, they must have proximity relationship between the plaintiff and the both defendants, and also need to proving that the injury caused to the plaintiff was foreseeable by the first and second defendants. However, in this case, the plaintiff failed to prove the existence of the duty of care. Both defendants had no sufficient proximity or need not the party who had a direct relationship with the plaintiff, as the appearance of the plaintiff is not due to both defendants. The first and second defendants also cannot reasonably foresee that the fire spread out due to the attachment of the hose and the short refueling dump, which caused the plaintiff to suffer such a severe injury. Moreover, refer to the Caparo Industry Dickman case, the Caparo test. It extended the test to fair, just, and reasonable for the imposition of a duty of care. In this case, due to the lack of the proximity and the foreseeability, the imposition of a duty of care to the first and second defendants is unfair, unjust, and also unreasonable. So, in conclusion, I agree with the judgment rendered by the court to the first and second defendants that they should not be liable for the accident or the loss suffered by the plaintiff. Now, that's all for me. I will pass to the next presenter.
BRENNA. So for my part, I will explain to you about the third defendant. According to this case, the third defendant had breached his duty of care because the defendant did not ensuring the safetyness of the crew members in the pit area. Plus, according to the video showed based on the judgment, it shows that the defendant did not ensuring the safetyness when the place was confined and packed with a lot of people and no attention given to the plaintiff presence there. Plus, plaintiff was not provided with security fuel suit when the refueling occurred. So, the court applied proximity test because there is a relation between the second defendant and the third defendant. Not only that, the Caparo test also has been applied by the court to see the existence of duty of care, and it was found that the third defendant had established and fulfilled all the elements in both tests, Caparo test and proximity test. In my opinion, I agree that with the court judgment saying that the third defendant owed a duty of care to the plaintiff. It is because when we analyze this case, the third defendant should ensure the safetyness of the plaintiff in the pit area instead of only focusing and only responsible for the sponsorship for the car race. Lastly, it can be concluded that the plaintiff has a right to claim against the third defendant for breach of duty and negligence. That's all from me. I will pass this presentation to the next presenter, Puteri.
Thank you, Iman. I will explain about the fourth defendant. In this case, the fourth defendant had breached the duty of care owed to the plaintiff as an inviting. The judgment based on evidence from the video in which, when the fire broke out, there was an uproar causing the plaintiff to be hurt. If the race stewards had been diligent, they should prevented the plaintiff from being in the pit area without a fire-resistant suit because the overall occupier remains on the fourth defendant. Based on the case of Hawkins against Colston, Lord Dennis states that If the occupier knows the premise of physical, a reasonable man will understand that it is dangerous. He must want an evitee unless the threat is obvious. In this case, the court also applied the Caparo test, which there are 3 parts of test. And for my opinion, I agreed for the judgment that the first defendant had breached the duty of care. The reasons: the first defendant failed to take all reasonable steps to prevent the plaintiff under his care from sustaining the injury. By applying the Caparo test, the injuries suffered by the plaintiff were forcible. When the court looked at the video, the court found that the first defendant failed to provide a proportionate degree of care to the plaintiff. Due to the lack of precaution, it renders the plaintiff claim actionable. Next, I will pass to the next presenter, BRENNA.
Thank you, Puteri. Now I will presenting and explaining about the judgment rendered to the 5th defendant. In this case, the judgment rendered was that the 5th defendant was not liable for the negligence toward the plaintiff. Indeed, the 5th defendant owes a duty of care to the plaintiff to ensure that the MMER races are safe to be run before a license is issued for the running of the race. However, the ratio decidendi in these cases was that the 5th defendant had done all required to ensure a safe race track, and the 5th defendant had already taken reasonable care in all the case circumstances. They also have the sufficient evidence showing that the scrutineers of the 5th defendant had inspected the track, and the official FIA had also examined the track and evaluated its safety. In these cases, for my personal commentary, I agree with the judgment that the 5th defendant was not liable for the incidents, as the 5th defendant had taken all reasonable steps and performed all the inspections before they granted the permit to the 4th defendant for the event. The 5th defendant could not foresee that the incident would happen and cause injury to the plaintiff. This is different with the previous case, that namely the Naga Nasional Malaysia and Batu Kemas Industri Sdn Bhd. The judgment in here should be different because in previous case, the Court of Appeal held that the first defendant had not taken all the reasonable steps to prevent the foreseeable incidents, thus they were liable for negligence. But it's quite different in this case because in our current case, the defendants had already taken all reasonable steps for the inspections. They have done everything that is required. It was reasonable that the 5th defendant, unable to foresee the accident would happen. It would be very unjust and unfair to impose such a duty of care to the 5th defendant after all reasonable steps have been taken. In short, I agree that the 5th defendant should not be liable since they taken all the steps. They done everything is required already, so they cannot reasonably foresee the incident will happen to them, will happen to the plaintiff. So I totally agree with the judgment. Thank you. So that's all for me. I will pass to the next presenter.
So in conclusion, the judgment here highlights that the significance of maintaining safety standards, especially in motorsports activity, because you know how dangerous motorsports activities are, and especially in the terms of when you are holding a motorsport competition, it is very important to hold on to the safety and holding guilty of parties accountable for irresponsibility. So we can see that when you act negligently, especially when you are doing something that brings in such effects, and from this case we can see that when you do something like that, you will be held accountable. And the fact that the court acknowledged the injury that is brought by the defendant's negligence was demonstrated by the fact that the plaintiff was granted damages for pain and suffering. And considering everything, the case highlights the legal principles of negligence and also the duty of care in the context of the athletic events. It established a precedence that it intends comparable to those two in the future. So in conclusion, just to put into simple words, whenever there's an issue that as the injury is caused by negligence, there will be consequences in the terms of where they have to be compensated for the injury that has been caused. That's all from me. Thank you.